first, we'll start from some theoretical issues, and after I will go to the point. I hope I finish it in 10-20 minutes maximum. So if something is too much, so say me, madam, you will see it. First question, I would like to say some theoretically basis for some theoretically concept concerning the diplomatic law and consular law, because usually these functions are normally bound in all the books concerning this part of international law, but in fact these functions are totally different, because diplomatic law, as far as treaty is concerned, is basically monosource system. It means we have only one convention. We do not have any other conventions concerning diplomatic treaty. The basic act of the global nature is the Vienna Convention of Diplomatic Relations. And in addition to this convention, we have only a single arrangement concerning diplomatic traffic. It means protection of diplomats in some fields of for example, terrorism or aircraft, and there are only few bilateral agreements between the Latin American countries on diplomatic asylum and nothing more. So we have only one source. And another question is that the diplomatic functions are essentially political functions. It means they are referred to activity of one state towards another, and they are often hidden. We do not know a lot about what the diplomatic functions are. Consular law is a complex legal system because throughout consular law and diplomatic law are often presented as a single common field of public international relating to the functions of the foreign service. In reality, in terms of both the material scope of activities and the formal basis of these files differ significantly. And consular law is characterized by duality. It means it is international consular law. It's something like internal consular law of states. From the international legal perspective, it's a branch of international law. The norm of international consular law are customary law, and they are dating back intercorporately to the 9th century, because we had something like capitulation treaties, consular jurisdiction, which is based from 8th, 9th century, 10th century. So it's a very old institution, and it was active till 1975 in some countries of Arab Peninsula. So it's really very, very, very old institution of international law. And a great number of bilateral agreements are also present in our practice. Especially, we had a lot of such agreements in our Middle European practice, because, for example, Poland has over 40 treaties on consular relations. I guess Hungary is the same. The situation of Hungary is very similar. I don't know how many under there. We have you have the consular convention bilateral. They have, I think, over 20. Yeah, I think so. So Czech Republic has over 40, so I think it's a similar number. Some, of course, of these treaties deal with the status of the consul, nomination process, immunities, privileges, and facilities. What's very important from the theoretical point of view, because the role of Vienna Convention of consular relation 1963 is completely different from that of the Vienna Convention of Diplomatic Relation 1971. Because usually the Vienna Convention 1963 on consular relation is used only where there is no bilateral convention. Bilateral conventions usually are lex specialis to this treaty. Of course, we have to mention that there are some differences as between this lex specialis in the meaning of consular law, as for example with lex specialis treaties in the meaning of Article 41 of Vienna Convention treaties. But in fact, it's used in the same mode. So what's also important, the Vienna Convention on Consular Act is not a comprehensive act. It refers only to particular functions, only those that involve the receiving state notification on obligations. So usually we do not have nothing about the functions. Only 4 functions of the consul are in the Vienna Convention, are regulated in Vienna Convention on Consular Relations. It is the problem of consular access to detained person. It is the problem of notification about the dead citizen in the consular district. It's the problem of minor without protection, which is not used in international anymore. And it's a problem of the crash of the aircraft of the ship in consular districts. So usually we do not have any information about the consular function in Vienna Convention on Consular Relations. But in the Vienna Convention 1963, we have something like classification consular function, because Article 5 of the convention divides them into those whose ability to be exercised by the consul is guaranteed by the international law. So we have the first group of the function which are granted by the international law, and those who exercise, and the scope depends on the receiving state acquiescence. It means on the approval of the receiving state. If there, for example, we have such function like notarial functions, like civil record functions, or voting abroad, for these functions, it must be approval of the receiving state. Without approval of the receiving states, consul cannot use this function in consular district, because they are not guaranteed by international law. In consular law, it's something called like Danish clause. It's not because Denmark has introduced something or Denmark is something with. It's because this proposal was introduced by Denmark and Northern delegation in the process of codification on consular Vienna Convention on 1963. The name is a little bit bizarre, I think. Yeah, and consular activities, what's important, they are, in their essence, are not homogeneous activities. They are divided into those groups. So this granted by international law, and those resulting from the Danish clause, resulting from the approval of the receiving state. What is important? In essence, consular functions are subject to constant change over time. Some normal activities, for example, of 100 years ago, no consul performs today. For example, the trade action of the consul, the factors on custom duties and so far, they were used normally in the 19th century. In today, nobody from the consular services of the states, especially our Mediterranean state, does not use these functions. Also, you can see such things in visas, passports, because in the countries which visa travel is in force, visa-free travel is in force, the consul does not issue visas. When passport-free travel is in force, he does not issue passports, and so far. So in European Union, in fact, we do not have such a function of consular representatives. Some activities are of the consul are covered by the receiving state lacks of consent to perform them. For example, in the field of the civil status, is often quite it's used quite often. So it is only one field of consular law in which we can see from time to time the lack of consent. This means there is no approval of receiving state to make such a function. For example, Poland has such a problem with Switzerland as a receiving country, or with Germany as a receiving country. They do not allow the Polish consul to make a civil status record functions. I am not sure whether it's the same in practice of Hungary. Also, from time to time, is also is a problem of notarial activities, but other activities are almost never affected. Okay. And I would like to mention also, because I will go to the first question of my presentation, I will mention also about the capitulation treaties. Because it's a very old traditional action of the consul, because in 1,000 years ago, the consuls in 9th century and 10th century have the possibility to take jurisdiction over the citizen. From medieval law, because medieval law were personal, or omnia meum mecum portor, so I have taken my right with, and this is why the consul used the jurisdiction over a citizen of his sending country. And we have gone from this capitulation treaties to the consular guardianship, because usually the citizen which were taken in a receiving state district was given to the consul just to take over him the jurisdiction. And now the information is sent to the consul not because of the jurisdiction, but because of the guardianship. So the consul have the right to access the consul to help him on something like this. In this time of treaties of capitulations, there is also it was also the archetype of many activities in modern consular law, including consular care, but also including such problems as legalization of documents or issuing the documents in notarial activities. So we have gone from so-called consular invoices, which usually consul produced in receiving country, to legalization. So it means to the process of giving the probative force to the civil law document instead of issuing this document, in fact. Yeah, the stamp. Yeah, we stamp only now. Before we produce this document, now we have the right to stamp because we accept the right of the receiving state to produce its own document and its probative force as being used in our country. Some words about legalization, because it's the first question of very, very strong impact of international law on the branches of the consular law. What's the legalization is? It's the mechanism for recognizing the probative force of the document. It's the action of the consul of the sending state against the document from the receiving state, which ensures that the document when submitted to the sending state will have probative force equal to the official documents of the sending states. It means the send of the usage of the document. Formally, it's the allowing the document to pass from the state where it was issued to the state where it was used. Legalization always applies to official documents. What's important, private documents arise separately from the activity of the state's bodies. It means so in the meaning of Marxism, they do not have homeland, so they are like communists. Private document in international law, they do not have homeland. So then they can be created really on the territory of any state as well outside of it. So this is why the council do not touch the private documents. It's not the problem of the official document in practice. Whether legalization is a necessity from the point of view of international law, it depends on the states in which the document is to be used. The sending states whose council provides legalization. States determine the extent of the necessity of legalization, therefore the extent of the probative force of foreign documents very different. I will show you the two examples. First one is the Polish Civil Procedure Code, because our probative force of foreign documents is regulated like this. So the foreign public documents have probative force on a par with the Polish public document. There are only two exceptions. The first exception is the documents concerning the transfer of the ownership of real estates, and the second exception is the documents whose authenticity has been denied by the party of the process, of the civil process. This first exception is really popular because many documents from abroad to Poland are concerning the transfer of ownership of the property, of real property. So they are the main thing, which is the main documents which have to be legalized by Polish consul. In Hungarian, but usually, and 90% of documents from abroad, they have probative force. They do not need legalization from the point of view of Polish legal system. From the point of view of Hungarian Civil Procedure Code is section 593, and the foreign public document deed was legalized by the competent Hungarian diplomatic mission on the place of the issues, unless another requirement is specified of international treaty entered into the country in which was issues. It means that we have something here which is also common, for example, for the Austrian system of legalization. It means we have all the documents should be legalized unless some different was written in international law, and we go to this point. Of course, in Poland it's quite the same. So unless there is something another written in international law, so we do not use the Article 1138 of the Polish Civil Procedure Code. And what is also worth to mention that the state's national council law do not define the scope of the legalization requirement, and only technically refer to legalization method. For example, the Polish consular law, Article 32, shows that the consul shall legalize a official document prepared and authenticated by receiving state. And the point 2, it's the technical condition of the legalization, nothing more than technically what to show, what kind of stamp and something like this, what should be legalized in fact. In Hungarian consular law, we have quite the same regulation in fact. What is important? The main issue is that the legalization mechanisms are usually abolished among the states. For example, by bilateral agreements, they have been concluded for this purpose for centuries. We have eliminated this condition, for example, in relation in all Central Europe. We do not have legalization of document. We do not have some necessity to produce the document with some official stamps of the embassy of the consular office. Because, for example, because there's of course the priority of the treaty. For example, between Hungary and Poland, there's Article 16 of the Agreement on Legal Aid and Civil Cases, which shows that documents which on the territory of the one contracting state have been issued do not require legalization for the use on the territory often of the other contracting party, and they have the same probative force of public documents. So they are used without providing conditions, Article 1138. Of course, we have also EU regulations concerning legalization, but they refer only to fragmentary issues, which is important. The European law hasn't gone to legalization so broadly like international law conventions, because they mention only to civil status records, in fact, which, for example, from Polish point of view, the civil status record does not need legalization anymore. It's because of our internal law. We do not need any consular stamps on these documents. But the most important, but not for our countries, because we have this turnover of documents without any necessity. But the most important, for example, from the point of view of our condition, of our relation with the United States, with Canada, with Australia, so far, is the convention abolishing the requirement of legalization for foreign public documents, called Apostille Convention, from 1st October 1971, and it's only the replacing legalization certification with apostille clause. It's not elimination of legalization, it's replacing, because now the consul has nothing to do with documents, but the documents must to have this apostille clause with these issues on this document in the country in which this document was produced, so in the sending country, in fact. In the receiving country, sorry, receiving country from the point of view of a consulate, and sending country from the point of view of the document. So, but in the country of the issue of this document. In this moment, what's the main target of this presentation in this area was that the legalization for consular circumstation is of diminishing importance. This is, of course, due to the Hague Convention's mechanism, but also because of the bilateral convention on legal aid, and this convention are abolishing the legalization in its entirety, and they, of course, take precedence over the Hague Convention. Such bilateral agreement takes precedence because it's special lex specialis, special law in comparison to Hague Convention. And I would like to mention to another field of international turnover, consular turnover, concerning the right to access the consul, because it's also something what we have because of our story, because of the capitulation treaties we had 100 years, 1,000 years ago in history of European civilization. Because in the past, I have told, consul was informed about the citizen arrested in his district because he had jurisdiction over this man. And now he received this information because of some possibilities to care, to take a protection over him, and so far. This problem was regulated in Article 36 of Vienna Convention on Consular Relation. We have something called facultatory right to access the consul, because everything is realized if the detained person requests to have the consular access. So it looks like this. If he so requests, so I mean this person who is arrested, the competent authorities of the receiving state shall, without delay, inform the consular post of the sending state if within its consular district of a national of the state is arrested or committed into prison or to custody, pending trial, detained in any other manner. Any communication addressed to the consular post by the person arrested in prison, custody, or detained, so far. This state authorities should postpone without delay. The state authorities shall inform the person concerned without delay of his right under this subparagraph. So, if the detained person is arrested, we have very interesting cases. We had 5 cases in International Court of Justice, and also one in International Court of Human Rights was one advisory opinion. about this issue. Of course, there are different cases. They compose something international law, something like grounds for international migrant rights. I have thought about it, I don't know, 2 years ago in Budapest, so I will not repeat this in this moment. But in fact, it's something like, you know, political, not political, it means right of fair process. So if you are arrested, you are for injury, you have the right to be informed by the policeman that you have a right to access to your consul. In some states of the United States, the practice now, because the first three cases was against United States. Of course, in every one of these cases, it was a problem of death penalty, nothing more. It wasn't a problem of consular notification in reality. It was the only problem of the penalty. In the fourth case, it was a case of on the international foreign investment. The person arrested wasn't killer, wasn't murderer. It was normal businessman arrested because of some, I don't know, investment problems or blackmail or something like this. And it was another question whether the person who was arrested was very, very known in Central Africa, and the information about his arrest was known to the president of bad states in 10 minutes after he was arrested. So it was really very important person. And this is why the country, Democratic Republic of Congo, hasn't done any consular notification. The International Court of Justice has told, sorry, the consular notification is a formal right. You should be informed about it, even if the information is broadcasted and every television tells you about it 10 minutes after the person was arrested. So it's formal right. It's part of the fair process rights. And the fifth case is, I think, is the most interesting because the case of the spying. Because the spy from India was arrested, but nobody knew that this man was Indian citizen. So it was the main problem. In which moment we should start this notification? So there are very, because I think, but another question was that this case was composed a little bit wrong by International Court of Justice, because it shouldn't be resolved by International Court of Justice, because it was bilateral agreement between India and Pakistan, and International Court of Justice hasn't recognized the agreement, haven't seen it in fact. So based his jurisdiction over on Vienna Convention on Consular Relation, it should be used bilateral agreement between India and Pakistan, and if this agreement would be used by International Court of Justice, this International Court of Justice wouldn't have jurisdiction. This is why he couldn't see this. He showed that I can see this the bilateral agreement. But the main problem here was in which point of time we should start with this notification. I think this point of time is the point of showing officially that is the national of the sending states. Pakistan didn't receive this information for many months. Because this man, this Jad Haf, was a spy, had 2 or 3 passports. Nobody knew which citizens he had. Okay, and so I have just told about these problems we have. So the notification should be done before procedural criminal charges, accusation, arrest. Of course, we have some problems with administrative detention, for example, refugees, person under the influence of alcohol, which are in prison for 24, 48 hours. What to do with such people? Inform consul or not to inform? There are problems which are not resolved in international practice. Notification should be made ever when knowledge of the detention is widespread. This is the Diallo case, and notification should be immediate. The time limits runs from the date of the citizenship information is obtained. And treatment of person of dual citizenship, of course, is another problem, because we should use the this citizenship which prevails, so effective citizenship in this moment. Of course, what's important, the impact of international law on this process of notification is also can be seen in some bilateral agreements. in many bilateral conventions. For example, of course, Polish-Hungarian Consular Convention, we have obligatory notification of detention. The will of the citizen is now important. So, because in Article 36 it's facultatory, yes, I'm just finishing. The will of the person arrested is not important because according to Article 73 of the Vienna Convention, bilateral convention rules have priority in usage. The same we have in Article 6 of the European Convention on Consular Functions, which also provides for obligatory notification. Poland is not a party of this convention, also neither Hungary is not a part of the convention. So only 5 countries from Central Europe are parties of this convention, from the Europe as well. So, the competent authorities of the receiving state shall immediately inform the consular officer of the sending state of the arrest or other form of detention of the citizen of the sending state. The will of the citizen is not important. And of course, there are some problems concerning how to see this protection system. You can see the clear influence of the human rights protection system on the design of consular norms. The consular normal analysis do not constitute a human right and can be seen as individual right, but they are part of the guarantees of fair trial and are seen as such. Of course, there are some possibilities of abuse, especially since such a perception is common only in the context of serious crimes, capital punishment, I've thought about it, and not the hundreds of thousands of situations per day when national councils of various countries apply Article 36 of the Convention on our mandatory notification mechanism. So, we have also this problem in European law, but in fact, because there is Council Directive of 20 April of 2015, but my colleague Anya will speak about European directives. I will be silent, keep silence in this moment. But there are some problems concerning the consular notification in this area. The main problem, of course, is that Article 8 of the Vienna Convention tells that upon due notification of the receiving state, in the absence of this objection, the consular office of the sending state may perform consular functions in the receiving state for the benefit of the third states. And it requires specific states performing functions and specific states on whose behalf the action is performed. Here in European case, everything is abstract. So from the point of view of the receiving states, these European rules do not exist in fact. This is why this system is in fact the protection granted by the system is extremely small, because there are few cases every year only based on the European protection. Only the massive evacuation of citizens in the event of foreign events like a war or natural disaster does have any meaningful dimension. Such normal access to consul of the person detained his liberty does not function, in fact, in practice. And the last question I would like to mention, because the impact of the international is very important, is the question which is of great importance, of a great benefit to the Council, is the consular activity concerning the transportation of human remains. We have 2 conventions. One was accepted in the time of League of Nations, and the second one is the Convention of Strasbourg of Council of Europe. But these conventions are in fact the same, because they provide something like laissez-passer on the basis of the documents produced by the country from which the remains should be transported. Consul does not have nothing to do with the body remains. Normally, consul have to deal with the identification of the corpse and the transport. Now it's if the country is a party of the Berlin Agreement, of the Strasbourg Agreement, both parties, so from which the transport starts, and the second one into this transport goes. There is, on the basis of sanitary certificates issued in the country of the dispatch, and this certificates are accepted in the country of destination. So it's very easy for the council. The council loves these agreements. But what's important, Poland, no Poland or Hungary, our countries are not, neither Poland nor Hungary are not parties to Berlin Agreement, are not parties to Strasbourg Agreement. They are not popular in Middle Europe, I don't know why, but in fact only Slovakia and Czechia are parties to both of this convention, because the sense is to be a part of both of them, because one of this convention, for example, the parties of this convention are Egypt, are Congo, are parties a little bit far from Europe, and in this Strasbourg Agreement there are 20 European countries, not only from European Union, but also from EFTA, Norway, Switzerland, so forth. So the sense for consular practice is to accept both of them. Why our countries hasn't accepted this convention, I don't know. For Polish consuls, it's really not very, I don't know, pleasant activity just to deal with the identification of the bodies. I think it's the same with the consular, from the consul of Hungary. I don't know, Andrzej could say something about it as a former consul. But really, the convention is very unaccepted at the time. Of course, there is some problem, I think, for smuggling the drugs, because the caffeine is the main source of smuggling the drug in the countries where the consul has no identification rules and cannot deal with this process. So maybe it's because of this. So, thank you very much for everything. Thanks a lot.